Give it a couple more minutes since people are still joining. Okay, I think we hit critical mass of the people who RSVP'd as attending. So hello, everybody. Welcome to the second committee meeting to discuss agency investigative procedures. I'm going to call roll, like I always do, of ACUS members on the committee. If you could please just unmute yourself so we can make sure your microphone is working, that would be great. Helen Saracio, our committee chair.
Here.
Thank you. Kayla Gammon.
Here.
Am I saying your last name right?
Yes, that's right. Thank you.
Okay, thank you. Devin Frey, alternate for Daniel Cohen.
Here.
Thank you. Nick Goldstein.
Here.
Thank you. Alice Kottmeyer.
Here.
Thank you. Erica Litzen.
Here.
Great, thank you. Jay Schwartz. Jay, you might still be connecting. We're just taking roll, so if you can unmute your mic and just say here, we just want to make sure it's working. Or we'll come back to you. Sid Shapiro. Sorry, I got you right as you were drinking water.
Yes, you did. Here.
Thank you. Peter Strauss, I don't see yet. Chin Yu, I don't see yet. Is there anybody else on the committee whose name I did not call? Okay, turning to non-committee ACUS members, Matt Weiner will be joining, but I don't see him on here yet. And then our consultant, Aram Gavor.
Hello.
Hi, thank you. Okay, I think that is it for attendees. I'll turn it over to Helen.
Thank you. You're doing that while switching screens. So 1 second. Sorry, everyone. All right. So I will go over our protocols real quick. So please note, only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, though, I'd ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. Then I'll call on you and you can unmute yourself. Please then remute yourself when you're done. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversation. With respect to attendees other than ACUS members and an alternates, please participate requires a unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points and will presume that committee members consent if absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you are done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak, or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Regulation Committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee, and we have a list of committee members in case you are unsure. And then I guess we can then go to the text to pick up where we were last session.
Yep.
Do we want to go, we pick up where we were before, or do we want to look at the edits that were integrated?
Yeah, so one of the biggest edits that we did circulate around last week was Peter Strauss's proposed edit to shift the order of things. So we did move some around. I believe where we last stopped would be 7.
All right.
And I know that we got a lot of comments regarding 8 and 9, so I do think that we should discuss those even if they were previously discussed.
All right, absolutely. Then let's pick it up with number 7, everyone. When an agency issues a compulsory process, such as a subpoena, warrant, or letter of inquiry, it should clearly specify the allegedly unlawful conduct by the subject that gave rise to the, thank you, as I'm squinting, thank you. Compulsory process. Agency should provide sufficient time for the subjects of the investigations to respond to compulsory processes before seeking judicial intervention. All right. I'm sure people have thoughts and comments on this one.
I'll just add that the red line that's in there now currently is a proposed committee on style edit.
I'll give everyone a minute to think about it. Any hands? Sid.
Do we think the words allegedly unlawful conduct is clear enough? That could refer to two things, or it might be helpful to refer to two things. First, what law or regulation the person under investigation is suspected of violating, and what activity led to that violation. And I was wondering whether we think that word unlawful conduct, it conveys one or both of those things, or we're interested in one or both of those things.
Thank you. Ron?
I think that's like a very, very, very good point. Just to unpack that a little bit, I think there's the basis for the compulsory process, which is sort of one bucket, and then it's connected to any potential conduct that interacts with the basis. So at least at a premise level, we might, just because you asked that question, it got me to start thinking, we might want to also include inspection, something like that. So there might be some compulsory process that's routine. It could be random, but it's still compulsory. You know, to retain your license, you still must submit to certain types of inspection regimes, etc. And there may not necessarily be unlawful conduct alleged, but we do, I think, this gets to your point. I do think the legal basis, or the statutory or regulatory basis for the compulsory process should be enunciated. And if that basis is activated with or by conduct or forbearance of conduct on the part of the target of the compulsory process, that too should be enunciated. Does that make sense? Just because the challenge is this is executive branch wide.
If you can recall it, I liked the language you proposed.
I think we're recorded. This is like a Sunshine on the Government Act recording, so that's good. Yeah.
I didn't catch it. I don't know if you remember what it was that you said, so I can just type it in red line.
Okay, so in the first line, I would also, before or letter of inquiry, after the word warrant, I would say inspection. So then you have enough optionality for what the compulsory process is. And then in the second line, it should clearly specify the basis in law for such compulsory process. And whether any conduct or forbearance of conduct and then I would delete allegedly unlawful conduct by the subject. And then I would delete the word that. And then I would write the word such before compulsory process. And then I will ask our colleagues, is that a sentence? Or at least a grammatically correct sentence.
Can I ask a question?
Yes, please.
When does an inspection, and is that delineated between a compulsory process, maybe a routine inspection?
So I think routine inspections are also compulsory. So it depends. Some routine inspections are non-compulsory, some are. So for example, if I recall correctly off the top of my head, it's like an old case. It's like Abbott Laboratories from 1967. You know, there's a compulsory process of allowing inspection. Notwithstanding that compulsory process, the factory owner can decline entry, and then in response to the declination of entry, the government can then take further action, which could include the removal of licensure for whatever the facility is producing under the Food, Drug, and Cosmetics Act. Another example off the top of my head is OSHA, right? So from a criminal law perspective, you could prevent a government inspector from accessing a space. But then there's other circumstances where, if I recall, under the EPA, you know, if you have EPA inspectors coming with a warrant, you know, let's say there's like a serious spill or a leak. Sometimes they may come with law enforcement. So there's just a very wide spectrum of what an inspection could look like. You know, it could be a wage and hour, like a Department of Labor wage and hour division. Sometimes inspections are scheduled. Sometimes it's a door knock. So part of what I'm trying to do is just to make it broad enough, but inclusive enough to capture the conduct that we're trying to form a recommendation upon.
Yeah,
Does that answer your question?
Yeah, so I just want to make sure we weren't accidentally bootstrapping in something that, like, let's say, like when we do issue a permit and it might have like routine inspection in there is considered, like when you issue a permit, that, you know, routine inspection is considered part, you know, a condition of that permit. Is that considered a compulsory process at that point then?
I would say,
yeah.
Yeah, that's a good question. I would say yes, but the answer to those following questions is very straightforward. What is your basis? Well, it's the authority to issue the permit. what's the conduct? It's routine, and it actually is not involving any discrete conduct of the permit holder. But then following that hypothetical, there are probably certain circumstances under which EPA, engaging in a permitting function, may have reason to believe that there is unlawful conduct or conduct that would render the inspection non-routine. And perhaps uses different procedures associated with that. Probably most significantly temporal ones. If there's like a violation, you're probably not going to be like, oh, we'll get to it in a year. You're probably going to prioritize getting there on site to see what's happening. And my guess is EPA probably gives some sort of piece of paper, four corner or something, some receipt of. I'm sure about that, although I don't know. So this would cover that basic level of, of process coverage.
Okay. So did we, Sid, did we respond to your question? Sorry, I got us on a tangent.
Yes, I like that language now that we have it.
All right.
If we're moving on in the next sentence, we say a sufficient time. Often those who are responding want a lot of time to respond. Agencies might not be so patient. And I'm just wondering about sufficient, maybe adequate.
I think
I don't feel strongly about that, but it's just, I wanted to raise that issue.
If I may speak, I think that's right. It could be sufficient, it could be adequate, it could be appropriate.
Appropriate is good.
Could be
yeah.
reasonable.
Yeah.
I invite you to pick your choice from the basket.
I would go for appropriate, but
Okay.
Other people might like another adjective.
Thank you, Sid. And I see Kayla has an editorial also on 7.
Yeah, just as a grammatical matter, it reads strangely to me to say when an agency issues a compulsory process such as an inspection, because the 3 other things in that clause are legal documents, and an inspection isn't a document, it's an action. So would be say something like notice of inspection.
Maybe it might be better to say engages in a compulsory process, because sometimes the inspection will be noticed. We're coming in a couple weeks. Sometimes it's like a knock, knock, knock. We're here for your inspection, and like they're giving the notice and they're showing their badge or their credential.
Yeah, so then maybe the clause could read something like
so issuing
such as an inspection or issuing a subpoena, warrant, or letter of inquiry.
I think that's reasonable.
Yeah.
Thank you. Good catch. Anyone else have any thoughts on it? And to clarify I did have a question on the second sentence, when we asked before seeking judicial intervention, or we're thinking Article 3 courts judicial intervention. Is that the
question? So if I might opine, I would say non-Article 2. So there are certain circumstances under which an Article 1 specialty court might be the entity that provides the intervention. But I can't think of it off the top of my head. but I know the Court of Federal Claims has like a wide and varied jurisdiction with like 16 or 13 different statutes. And there could potentially be a circumstance under which like a non-Article 3 court, but probably outside of Article 2. I would not think administrative law judge would be styled as judicial intervention.
You saw where my question was going.
Yeah, totally. And you know, most non-Article 2 courts are indeed Article 3 courts, but not always. So then the question is, do we need to distinguish? Make that clear.
Was
Non-Article.
it, yeah, I guess, was that unclear for anyone else on the call, or was it just me? If anyone else feels like we have to clarify it, or if not, I'm happy to move on. So I will leave it to the majority on that one. We can think about that one too. So it doesn't have to be decided at this moment. Anyone else have any other thoughts, edits on number 7, or we can go to number 8, which I have.
Yeah, so we had a couple of a couple of comments on 8. Some of them overlap with each other. Kayla, I know you submitted one, and I think you submitted a comment in response to the previous version of the recommendation. So I also just wanted to check if how much this still applied. There was another comment also from Peter Strauss here. He had wanted to say should ensure that agency heads, instead of agency heads, the appropriate politically responsible actors. Committee on Style suggested agency heads or other high-level officials. So that is something that I think the committee definitely needs to discuss as well.
Sorry, I'm Chinyu from the FCC, and sorry, should I have done that? Sorry, we use Teams, so I'm trying to remember how to do this.
Okay, I did see Aram's hand, and I know Aram, maybe we will to like explain why what you thought about this. I know we had a conversation about this first, and then well, I know all the federal members on here will have their opinions about this that we'll want to talk about, and then everybody else will have their opinions too, and then we'll come to some sort of consensus about moving forward. I know this one is going to be a robust discussion, so.
If I could start, I actually love Peter's or politically responsible actor.
Why? I'd love to, can we?
So there's, so just unpack it a little bit. At least in Trump 45 and presumably now in Trump 47, based on various rescissions of 46 EOs. There's an EO out there that requires only a pass official, like a Senate confirmed principal officer of the United States, may sign a regulation that is then transmitted to OIRA or to the Federal Register. And seeing the broader scope of how the federal courts are construing the Appointments Clause, Article 2, Section 2, Clause 2, so off of the Constitution, with the distinction between principal officers and inferior officers. My thinking and recommendation requiring a high level of seniority here, initially the ultimate level of seniority for approval, is that it is most constitutionally sound in a highly dynamic separation of powers litigation space where the Supreme Court is invariably moving towards a more formalist interpretation of the Appointments Clause So I'm not seeing cases where it's sort of like ticking back the other way into functionalism. It's becoming more and more and more formalistic. So hearing from what Peter said, politically accountable official provides sufficient flexibility for the executive branch, regardless of administration, to have that level of oversight over compulsory investigative procedures. Now, normatively, how that could be done, given how busy these people are, as we know, it could be simply in the context of like batch approvals, right? There could be 1,000 of them in a list, and it's like a checkbox sign off. You're still accountable for it. There's no obligation for you to like physically read every page of every proposal. And for independent agencies, or based on the president's recent executive order, so-called independent agencies, that type of direct political control flowing down from the president to the agencies themselves really requires a locus point, the past officials who are leading those agencies. So happy to sit back and allow the discussion. This was a recommendation. It's clearly a normative one. It's one based on observation of where things are headed and where things currently sit now. And whatever the conference wants to do is its judgment.
Thank you. Jen?
So I admit I've been following appointments clause cases, but not necessarily in the context of investigations such as what we're talking about here. But I guess, what I am familiar with is with our agency's practice. And I didn't quite understand the the policy rationale behind having high-level officials or agency heads be responsible for signing something at the outset of an investigation. Of course, as the investigation becomes more mature, there are, places in our process where the PASs do get involved, but I'm not, I, but I did want to ask Professor Gavor that what the, rationale was for this particular stage in the process.
So what I can also share is, so you have FCC's behavior, SEC's behavior is at the sub-commission level. But for example, CFPB is actually a good example because that was at the time of inquiry and data collection, lower level approvals beneath the agency head was appropriate. But as you might have seen in the first 4 weeks of this term, no investigations are to happen unless I think like Mark Paoletta or another, the acting head of the agency is authorizing it. So there's already current practice that has shifted from the date of collection. Chin is totally correct. And that's one of the challenges with this fun project is there's like almost no case law on agency investigative procedures, which is why it's like fun and sort of edgy and ahead of the game for ACUS to get involved with it in the first place, right? So that's like the mandate with which we're doing the work. But in the context of the results of those investigations, and certainly at the point of enforcement and adjudication, the authority and the oversight of the adjudicators, you have like Axon and Arthrex. Some actions are not even, competent for the agency to decide anymore at the agency level. That'd be your Jarkis's 7th Amendment common law tort behavior. And in other settings, there's earlier and immediate access to the Article 3 courts, especially if there's a constitutional challenge to the agency adjudicative premise. But with regard to the seniority, you can look at the like the PTAB cases, which really require political oversight and direct oversight, and the term being like a double peekaboo, wink, wink, nod, having like multiple levels of insularity from the president for the adjudicator is a thing of the past, in part jurisprudentially, and then versus executive policy, the president is clearly asserting more direct control over the agencies, and consequently, the recommendation from my perspective is that at the investigative stage, there should be that associated politically accountable control, which is why I reacted favorably to Peter Strauss's recommendation with regard to politically accountable without us having to define it.
So I would say if I could just take a couple more minutes, that's very helpful. And I certainly have no interest in disagreeing with, ideas of political accountability. I would say in our experience at the FCC, if we have major investigations, certainly the chair is very much aware of what's going on. And so there is reporting and accountability. I think the concern I have with this recommendation, again, is the idea that a high-level official needs to approve and sign things like subpoenas or, more often with us, what we do are letters of inquiry. Because we are responsible, for example, for enforcing violations of our robocall rules. Everybody hates robocalls. We do, use both letters of inquiry and subpoenas quite a bit in that exercise, but candidly, the number of violations is such that, I don't think our chairman wants to sort of quit the other parts of his job and sit around signing robocall letters of inquiry or subpoenas because the fact patterns are not at the initial stage of investigation. When we're just trying to get more facts, that to me is something that we've always kind of allowed to be delegated to lower level staff if the fact pattern is not particularly complicated. Another example I would give you is the case that was argued at the Supreme Court on Wednesday, the Universal Service Fund case on contributions. We go after people if they don't pay what they're supposed to be paying. Again, that is not necessarily a complicated exercise. It can be as easy as saying, going after people who just have flouted the obligation to file and pay. And so I think the concern that I would have and our Enforcement Bureau folks would have is that for a lot of these investigations, is not a good use of resources to have a high level official, even the bureau director, be personally responsible for signing them, especially because that would take more time. And we have a 1-year statute of limitations beginning from the date of violation to do enforcement. So that is also probably going to conflict with the recommendation above, I think, that agencies move expeditiously. So I've taken up enough time, so I've said my piece. Thank you.
Helen, you're muted.
Sorry, I'm the one on mute. Sid, sorry.
Can we go back to Peter's suggestion, the language you used, please? I'm not sure what he means by appropriate politically responsible actor. Aram's suggestions, I think he used the word politically appointed. I'd like to think that bureau directors and in fact even fairly low-level attorneys are politically responsible. So if we mean politically appointed, I think we ought to say that. That said, I think what we just heard and what we're likely to hear more of is there's so many different kinds of compulsory process that Chin's comment really rings true to me. It was many years ago, but this is basically what I did as a government attorney. And the thought every time I issued a compulsory process, if I had to run to the chairman, even or my bureau head, would have just been really complicated, because then you got to explain what you're doing, you got to explain your case, you got to explain what came up. It's very complicated. And so I think that's really the issue before us, given all the various varieties of process across the government. Is it really efficient to have a political appointee approve each and every one? All that said, I agree that it may be legally necessary before the Supreme Court gets done. But as a policy matter, I think we're caught between where we think the Supreme Court might be going and what is an efficient and appropriate way to handle process.
Thanks, Sid. Kayla?
I am thinking along the same lines as other members. You know, the NRC had 61 significant enforcement actions last year. If we add in inspections, that's hundreds more. I think if I were an agency head and these were given to me for approval, I would want to do more than just check the box. If I'm going to be politically accountable for that, I'd want to look into each one of those actions. And maybe I can delegate that to my staff, but our commissioners don't have very large staff. So if this were implemented at NRC, I expect we would either need to dramatically cut down the number of enforcement actions, or we would face waiting months or years for a notice of violation to be issued.
Thank you. Aram?
I think that's good feedback, and I think it's especially Chen and Kayla, their experiences that makes a lot of sense. I think Sid frames it pretty well. My point in response is that as opposed to, let's say, outright or serious enforcement actions, which is the post-investigative conduct, or commission level actions where you have like a full-blown packet, all of the papers and the facts, and you're reading it. Having there are ways to fast track procedures where there's political accountability and follow-up in the context of, as I mentioned this earlier, batching. So what the politically appointed, so I agree with Sid, it should be politically appointed. But the word, I think, I would guess that the word accountable, from what Peter is saying, actually means appointed, because career people, I used to be one. Of course, we are upholding our oath, but usually when you're using the word political in reference to accountability or responsibility, that typically refers to being a officer of the United States. Sometimes you have SES people who are officers of the United States, right? That's reasonable. But I do think having batch level approvals, especially for non-controversial actions. So I wouldn't want to slow down agency behavior, especially as Chin is describing, there's a 1-year statute of limitations, so things got to keep moving. And then as Kayla's describing, there's hundreds of inspections that take place for the NRC. And I think those examples are sort of exemplars of the broader executive branch. So there's ways in which this could be formulated where that approval is not you have to sign every page in the memo in a long format before then an investigative act takes place.
Thank you. Sid?
Is a possible way out of this to say that a politically appointed official ought to be notified in those agencies where it's subdelegated to a bureau head or something like that? That allows political oversight by a politically appointed official without the need to approve each and every investigation.
There's that too. I'm also wondering if we have now overly defined what is a compulsory process by putting inspection in there. I'm wondering if our definition of compulsory we need to think about. Once again, going back to, we can have inspections that are routine inspections that are not part of an investigative process that might turn into an investigation due about the inspection, versus something that is part of an investigation process. So this is a question for everyone. Is part of our challenge how we're defining what is a compulsory process? And as part of our challenge, are we still clear in number 8? What is the it we're trying to solve? Aaron?
That's a good point. In one respect, I think even routine inspections should have what's our authority to inspect and why are we inspecting? Which can be very, very simple. It's like you have a license under the statute, and under like paragraph 14 of your license agreement, this is the inspection. I also agree with your point that I don't think high-level agency approval is what I was getting at with regard to those types of inspections. So I would almost even say it's sort of non-routine inspections is the type, like something that makes it outside of a routine is really the type of thing that, you know, where that sort of serious focus lies. So I'd feel comfortable saying a non-routine inspection in paragraph 7, while also hoping that for routine inspections, you know, the printout or the, you know, the paragraph that almost everyone gets with these things is still good conduct. I also agree with Sid. And this is, you know, this is something for the conference, right? Like, so I'm putting the idea out there for the conference to decide upon. It's not like a me thing. So notification undoubtedly is more than what we currently have got. And that's definitely better than the current state of affairs. So I want to observe that. And that certainly is like a downward titration, you know, from approval or even batch approval. And that's for the conference to decide. And I'm just trying to, you know, be the reporter and to help the conference.
So far, Ada, are you saying that it's notification to the high level official that these processes are happening?
I think it's actually appropriate for all of those routine inspections for which records already exist, and they probably already exist in a centralized, delineated format with sufficient clarity, like even if it's like cells on a spreadsheet, for the agency head. So now, like, if it's just notification, it really should be the agency head, because typically notifications flow up through the chain of command to the agency head. So there's like a positive value proposition for just making it to the agency head of just what's going on. And I think that is appropriate for an agency head to know what's happening within the agency, at least to know what's happening, to see the volume of it. And then if that agency head has any questions. So in Chin's circumstance, the FCC is more of like a, that makes total sense. You know, that's pretty formulaic and normal. The CFPB process, it also allows for the CFPB acting head to, they want to consolidate all authority, to even authority to engage in the continuity of work. That's also provides optionality for that as well. So I think Sid's observation could be attractive to the conference, looking to balance all of the interests, because informational sort of rights to a politically accountable, you know, the ultimate politically accountable head for the agency is, at least in my view, a pretty basic proposition. So like in the Justice Department, we provide reports at all times for what's happening in the litigations, all litigations, to the agency head. So that would be like the Civil Division Assistant Attorney General. Then the significant litigations then sort of get moved into a separate batch, which longer form, and then even more significant litigations get associated with part of the entire department's litigation report to the Attorney General. But at all times, anyone in the political leadership of the department at any moment can immediately see every litigation that the Justice Department is handling. Yeah, it's like a line item. Which district, what's the name, what's the attorney assigned? Typically, what's the court code? So habeas, APA, whatever it is.
So I just wasn't sure on 8 if we thought we were trying to solve a more future Lucia upcoming problem, or if it was a transparency for the decision maker problem. And if we had coalesced as a committee on that.
My reaction to that is it's all of the above. I am seeing all signs pointing in this one invariable direction. But I think I'm actually going to
Okay.
intentionally not
Okay.
talk for like 10 minutes.
That's good.
Unless you-
This is good because I want the whole committee to, like, all of us intentionally knowing this is what we're all working on together. So thank you. So that's for the whole committee to look at, to then balance against the efficiency that for the committee, also for, for the people that are the federal agency members, the efficiencies for delegating downwards to other levels within the agency to be able to get the work done too. How do we counterbalance those tensions? Any other thoughts from folks about ways to balance those two needs? Any edits? Suggested language? One thought could be not making this compulsory language at this point. One could be is making it a suggested language. They could consider doing this.
Could you pull up the language again, please, if we're going to talk about exact wording?
Sorry, Kayla, what language?
I have recommendation 8.
As in your comment?
No, the draft language itself.
So I didn't get any, unless you're talking about Peter's appropriate politically responsible actors.
Someone was sharing a screen with the draft recommendations earlier, but I don't see it. Is it just me?
Yeah, I'm not sure.
Yeah, I think there was one earlier. We could all just look at the language again. That would be helpful, I think.
It?
Here's some suggested language. Agencies that engage in compulsory process should notify the agency head of the use of such process when the authority to engage in compulsory process has been delegated to other high-level officials.
What do you think the notification would look like?
That would I think for reasons Aaron's pointing out, we ought to leave that unsaid. I mean, we particularly his idea of batch approval, this would be batch notification. It just so many circumstances that I think notify is you gotta let them know. It seems to me a good managerial process of practice in any case. And whether it's legally required or not.
Mhm. Thank you. Reactions from folks?
Do we want high-level officials in the sentence in that case, or would we want agency heads to be notified when that authority is delegated to anyone?
I did use the word high level officials. Yeah. Picking up on the language suggested by the staff.
So you would not want them to be notified if the authority is delegated to lower level officials?
Oh, wow. Very good. Yeah, I guess I was anticipating it would be one or the other. So I was assuming that we're not going to delegate it further down than a bureau head or something, office director or something. But that does complicate the issue, I agree. So to answer your question, I think we do have to leave out high level unless we want to restrict approval to the director or high level officials. And punt on the notion of whether they have to be politically appointed to await further developments.
Thank you. Other thoughts? You can set on this one.
I think Aaron's right. We ought to come up with language that the committee likes, and the conference may well have something else in mind.
This is true. I'm sure there'll be more discussions on it.
I think we could count on that.
Anyone else have any thoughts on it? This has been a really robust conversation, so thank you, everybody.
I liked what Sid said, but I didn't write it down. So, yeah, I think it makes sense to try to come up with some language. But it'd be helpful to see the exact language on screen.
Oh, well, what we typed it in. So it now says
Oh.
agencies that engage in compulsory processes should notify the agency head of the use of such processes when the authority to engage in such processes has been delegated to other agencies officials.
That makes sense to me.
Katja is so efficient. She got it typed into the screen. So thank you. That kind of leaves then to the discretion for the agencies to determine how often they do it, when they do it. But it does, then they are providing the information to them. Yes, is everybody seeing the screen share? That is a good question. Oh, is everybody not seeing the screen share?
That was
That-
what I was asking for earlier.
You have to
Oh,
the ACUS's screen. Okay, now I'm seeing it. Okay.
Kayla, are you able to see it now? You might have to navigate to another window.
Yes, thank you. I had no idea about the tab.
Sorry about that. There we go. Sorry about the confusion. All right. If everyone is okay with 8 for now, and of course we do have another meeting, one more too. So if we want to move on from 8 to 9 for now, we can move to 9. And let's see what
Yeah, so there was also a comment from Peter regarding the relationship between 8 and 9. And then I think this, the proposed language that's in there, Helen, addressed your comment from the last meeting as well.
Okay, great. So first of all, 9 says agency should establish processes for administrative review of decision regarding compulsory processes. Such processes should permit review of an interlocutory basis or at least before the agency seeks judicial enforcement. And then we have, is this a comment? Oh yeah. Okay, so do we want to go to, what was we can go to the first comment. Is this Peter's comment?
Yes.
Peter, do we want to go to you first?
He's not on.
He's not on. Oh, he's not on today. Okay. So,
No.
all right. So let's look at Peter's comment. Confusion between the relation between 8 and 9. Where would the appeal go? So if it's an administrative. All right. So did our recent edit solve his confusion between 8 and 9? Maybe.
I suspect it's probably resolved by the use of the word notify, but in instances where maybe an agency head is still involved in those processes, it might be relevant.
As applicable, should establish processes for review.
Perhaps. Yeah.
Yeah. Not all of ours have like judicial, some are only administratively enforceable, some are. That's why there's such review on an elected basis before. Sid.
Am I wrong? Isn't 9 supposed to be at the behest of the party that's subject to the compulsory process? And that's the difference between 8 and 9. And if 9 is about that, shouldn't it say something about the person who receives the subpoena or whatever should have the opportunity, assuming it didn't come from the chair, to use an internal administrative process?
Excellent question. Adam, I think y'all wrote this. What were we trying to achieve here?
I can definitely try to help clarify that, Helen. And, Professor, I do think that you're absolutely right. This is more about the individual being served that compulsory process. So I think maybe it would make sense to include something in 9. So it says, currently, as applicable, agencies should establish a process for administrative review of decisions regarding compulsory process. Such processes should maybe allow the individual subject to compulsory process. Maybe that could be the language that we go with.
What do you think, Sam?
Oh, I'm sorry. Yeah, I think that does it.
No, any other thoughts? Kayla?
So I'm going to float an idea that I'm not sure I completely agree with, but maybe it will help me understand the thinking behind this recommendation. So as I understand it, the rationale is that the rationale for this layer of interlocutory review is that responding to a compulsory process takes effort, burden, maybe expense. You know that you're responsibly scrutinized. Maybe you have to hire a lawyer to respond or do internal investigative things. Should this be applied differently when the compulsory process can apply to anyone in the country, as opposed to an agency such as mine, the NRC, where everyone we're issuing these compulsory processes to is in some way involved in a highly regulated industry, and they're already on notice that they are going to be subject to regulation, inspection, requests for information, and all that sort of thing.
I'll just offer up that we might want to include non-routine again. I don't know if that would capture your concerns or not.
Are we concerned that everybody and their uncle subject to compulsory process will take advantage of appeal?
Hey, so my thinking is, so Kayla has a good point. Her agency is almost unique. Not almost unique. It's one of the fewer agencies where, just like, if you have any business before that agency, it's like in a highly regulated space. FCC is, in comparison to NRC, less regulated, although there's still a significant amount of regulation. SEC, if you don't have a certain amount of profits, you're not really subject. You're subject to SEC rules, but you're not yet subject to SEC direct regulation. Another example, Board of Governors of the Federal Reserve. It's like a switch. If you are subject to regulation, it's full-blown regulation. So I think the concern that my research revealed, which is what undergirded this recommendation, is for those industries that are not necessarily within that hyper-regulated space. Although there is some possibility that industries in a hyper-regulated space would benefit from having a second bite at the apple or a fresh set of eyes before something goes into full-blown enforcement. So hopefully that helps. And the optionality, I think, of the interlocutory basis is really important, because I don't want to make it mandatory. If it's mandatory, then Sid is right. Then it's just everyone's forced into it. But I think there's a lot of entities that will either avail themselves or not. But having that option can be helpful. It's especially helpful because even utilizing an interlocutory agency appellate process is an expenditure by the regulated public, right? It takes some level of effort to do that. You have to take some affirmative step. You typically need to make some investment. So that friction point is actually a market efficient one, I think, so that you don't have just everyone always using it all the time. That's usually not how it works. So like for another agency, United States Citizenship and Immigration Services, there's an entity called the Administrative Appeals Office or the Administrative Appeals Unit. That has the ability to take optional sort of agency appeals that doesn't disrupt the 704 process unless the option is exercised before the Article 3 action then can take place based on a final adjudication at the agency level. Now, obviously, this is earlier on in the investigative stage, but my example of non-utilization of an optional process is very well undergirded in that example. It's very rarely used, but sometimes it is.
Yeah. So I guess I have a question for you then. So what is it they would be appealing in the investigation? It seems like there's a huge leap here. Like you're still in the investigation. What would they be appealing before you'd even, like you might not even be going to a judicial enforcement yet. So what is it they're thinking the appeal is?
That's a very good question. So the appeal would be on the basis of, do you have the authority to investigate at all? Like at the most foundational, we start with premise, right? It's you shouldn't be knocking on our door for that. That's something that's different from what you've done in the past. That would be one. The second would be the scope. You're asking for too much relative to the thing that you have the mandate to investigate for. And then another would be is like you're being quite onerous with this process. So if it's like, hey, here's the CID and we're going to tee up. So this is something that the Trade Commission has historically done, at least in the mid 2000s. Case called LabMD, another one called D-Link Systems. They would tee up at an investigative process. We're going to have something like, like 20 interviews at different places in the country, all within a 3-week period. Well, that doesn't sound great, in terms of that might be something great for an interlocutory. Hey, can we spread this out a little bit? And are all of those interviews needed, relative to the thing you're investigating? So really what I'm describing is something that gets deployed where the target of the investigation has a basis to think that there's some level of excess or aberration in the investigative process. But for, let's say, your garden variety licensure-based routine inspection, the scope of review is like, is there a license? Okay. Is the license authorized inspections? Okay. Is this something that's based on the license authorized inspection? Okay. No. Like, so it wouldn't disrupt any of that.
Well, this is helpful.
Yeah, thank you. That helps me understand the thinking behind this.
So it sounds like what we're seeking then is an ability for people to appeal the compulsory process itself. Sid, I see your hand. Oh, you're on mute.
This does relate back, I think, to our discussion in 8 about whether the compulsory process needs to come out in the first place from the head of the agency, politically appointed official. And so what we said is, assuming we keep this, that lower level people need to notify the head of the agency or a politically appointed official. And then B, that person does have the ability, if there's an appeal, to make the final decision on the appeal. And so that might give agencies more flexibility, even if the Supreme Court does change who can issue these things. Because notification gives you the ability to say no, and appeal gives you the ability to say no later on, or not so much.
It's true. Thank you. Anyone else have thoughts on this? Adam, the one question I had for you is on the judicial enforcement, were you thinking that the judicial enforcement would be of what's the enforcement? Is the judicial enforcement is of the compulsory process you were thinking of?
You're absolutely right, Helen. So in taking what was sort of cited in the report, it was, we're taking it another level. We're taking you to like the Article 3 court context. So that's why I differentiated that between adjudicatory.
Okay, thank you. That's helpful. Thank you. That's all I have. Anyone else have any other questions or suggested edits? If not, I know we've been at this for over an hour. Would everyone like a 5 or 10-minute break to be humans? I know I would like, yes, I see a hands up. How about 10 minutes to make a tea, coffee, go be humans, and then come back with fresh eyes? I see no, thank you. I see no thumbs down for that one. So how about at 2:24, we come back. I see no objections to that one. So let's go stretch our legs and get some caffeine and come back to reconvene then. We are taking a 10-minute break.
Lovely. Thanks.
Welcome back, everyone. Thank you for that much needed break. Thumbs up, we're all back. Or if you're like me and we still I'll give everyone just one more minute back as we go to our 10th recommendation. This one's on initiating enforcement and determining the appropriate course of action following an investigation.
Yep, so I'll just add, Helen, that Peter Strauss also submitted a comment to change end stage procedures to initiating enforcement. The committee on style proposed edit would be determining the appropriate course of action following an investigation, since not all end stage procedures result in initiating enforcement.
Seems like a common, I like it. Let's see how everyone feels about that edit. If anyone is opposed to it, I don't see anyone opposed to it. Are people still making their coffee? Well, looks like it's a good edit. We'll keep it in there for now. Thank you. On to our 10th, number 10. Agencies should direct enforcement personnel and include enforcement manuals, how they should consider evidence relating to investigations before recommending or conducting enforcement or other administrative actions. Such considerations should include the appropriate standard or proof an agency must demonstrate in administrative proceedings, whether that standard differs from the preponderance of the evidence standard used by federal district courts in civil cases, and where the burden of proof rests in particular cases. All right. First proposed edits, mine, so I guess I'll own it. We thought we'd put in there enforcement personnel because this is about enforcement. We thought that made sense. If anyone has a problem with that, let us know. Talk about it. Any other thoughts or comments? I know this is kind of a robust paragraph, so we can take a minute to look at it and then. Anyone have any other thoughts or edits they want to do or concerns? I don't see any hands. If not, we can move down to number 11. Look at that. Number 11, agencies should provide and include in enforcement manuals the relevant factors for enforcement decision makers to consider, including any supporting documentation such as justification memoranda when determining whether an investigation should be recommended for enforcement action or termination, or to offer or enter into a settlement with the subject of the investigation. Any thoughts? Edits? No. Don't see any hands. All right, we can go to 12. Agency should provide notice to the subjects of investigations before an enforcement action is initiated unless compelling reasons not to do so. If the agency decides to initiate such an action, the notice should provide. And we've got the several factors. I'll give everyone time to read this one. Chin.
Yeah, I was just wondering what a compelling reason might include.
Right. Adam, you have thoughts on that?
Yeah, so I guess in framing this with sort of the caveat of compelling reasons not to do so, we didn't want to make it so broad that, there should always be notice. We know that there could be circumstances in which an agency might decide that notice isn't appropriate. We know that the vast majority, at least in perusing a lot of the case studies in the report, it seems like most agencies don't provide this sort of notice. The exceptions would be CFPB NORA procedures and SEC Wells notices. So I thought that it was important to cabin, but if the committee feels like a more general approach is warranted, I think that it would be within or well within the spirit of the report to take the compelling reasons language out.
Well, no, actually, I was we had a couple of concerns because, well, one is we for certain types of investigations, the statute actually says we shouldn't give the target notice before doing an NAL. And then we were also concerned that there are certain targets that if they get notice, they're just going to evade process. I thought probably those might constitute compelling reasons, but I just wanted to check.
Thank you. Sid?
I'm not quite sure about the scope of this. First, if the agency is required to use formal adjudication, type A adjudication, there's a notice requirement in the APA, and there's a fair amount of law as to what that notice has to require. Secondly, I'm surprised to hear that agencies don't notify. Basic due process says that at a minimum, you need notice and some opportunity to appear. So I've always thought, it could be entirely wrong, that there had to be some sort of notice that we're about to enforce this against you.
Thank you. I think Aaron?
Sure, I just wanted to respond to the one point where just a general maxim, I don't think anything the conference does should trump a statute. So I even think like even the text unadjusted should never be read to trump an otherwise statutory requirement for a specific agency.
Did you have any thoughts on Sid's question on the APA and investigations, or Adam?
So let me pull up like 5 US Code 555. I think there's some stuff in ancillary matters. Okay, I'm just like, so it's like 555E. Prompt notice shall be given of the denial in whole or part of a written application, petition, or other request of interested person made in connection with any agency proceeding. So the question is do we define an investigation as part of an agency proceeding? My operating assumption is that agency investigations are not regulated by the APA. They're sort of like pre-proceeding. But the principle of like letting a target know that they're done is a really, really basic one. And that 555E certainly lays out APA policy with regard to sort of, the next level, something that arises to a proceeding. So hopefully that helps.
I don't disagree. I don't even disagree with the recommendation. I was just trying to reconcile it with if an enforcement action is started, there's going to be notice. So it's just notice that we're going to give you notice that an enforcement action is about to be started, assuming you're not statutorily precluded from doing that.
Okay.
Oh, on that score, I think that could be valuable for sure. And you're right. If it's a formal adjudication, there's a notice requirement built in, so it wouldn't make sense to add something. But if it's an informal, and sometimes there are informal enforcement actions. And then there's the other question as to whether an enforcement action is even regulated by the APA also. Like, is that an adjudication or is there something else? And there could be some certain, this is the fun part with this project. It's sort of like APA, like it's like APA adjacent and like implicated, but it's not like really direct APA. So then there's these fun foundational questions that we get to sort of work through.
You. Chin, I see your hands up.
Yeah, just wanted to make sure I understood this correctly, which maybe I didn't. On 12, I thought the first sentence was about giving notice before an action is initiated. And then the second sentence talks about what notice there should be after there's a decision to initiate the action. So I had initially read that as a second notice. Did I read that wrong?
From what I can say, I view that paragraph, so we're talking paragraph 13 or 12?
12, sorry.
Okay. So let me just go through it. I'll let Adam answer just because he's the prime driver.
So if it didn't come across as clearly, Chin, I think that my goal was that this would be the same notice. So you have a notice to provide the subject of an investigation prior to the initiation of an enforcement action. And then within that notice, that's sub A through E. But we can certainly manipulate the language for clarity.
Yeah, I'm not sure that you need the phrase that says if the, yeah, I don't think you need that. That's much clearer. Okay. Thank you.
Thank you. Any other suggested edits or comments? Seeing none, we can move to 13. Which has been edited. Kasia?
Yeah, so I'll just add that there's a comment in the side that just we wanted to propose this language and then have the committee discuss, and I think this was based on previous discussions from some of the above recommendations, and also some other concerns from Helen, I think from you and some other folks about no action letters. So we did adjust the language to remove no action letter, because we do think that that means different things to different agencies as to whether or not they are, I guess, like binding, or whether or not they indicate that agencies will not take future action. So this was the proposed edit to kind of combat that confusion.
Thank you. Thanks for making those edits too.
Yep.
So the new language would say when agencies terminate investigations, they should notify the subject that they have done so. Looking at folks' reactions. Kayla.
I'm not sure I'm following the distinction between a no action letter and notifying the subject that the investigation is terminated.
Karen?
So this, just to clarify, the distinction between a no action type letter and a simple notification of termination of the investigation is that a no action letter can be used as precedent potentially and create a bit of a safe harbor for the conduct to then just, continue. So a more conservative approach is what I'm guessing is what's happening here. Is that just noticing, providing notice of termination provides the ability for the agency to pick up again if they want. In terms of what I recommend as best policy is you get your one bite of the apple, and unless something changes or like a new fact emerges or something like that, that was the bite of the apple for the agency. But that might not be something that can achieve consensus.
And so as edited, I would read this as giving the agency the option to issue a no action letter if they choose to do so. Okay.
The committee might even say, in a second sentence, in such notice of termination, the agency may style it as a no action letter, as in like we're now done. Feel free to continue engaging in your conduct in the marketplace without worrying, that we're just always going to be breathing, down your neck. But that doesn't necessarily have to be mandatory. So there might be consensus on at least encouraging that if it's appropriate to do. And again, the term no action letter is not something I came up with. It's like an agency practice that some agencies use. By the way, like I'm intentionally going like screen dark to sort of force discussion.
Any other thoughts on this one? Anyone needs to sit on it for a while and think about it. We've got one more committee session, so. We can go to number 14 then. negotiations and settlement procedures. Agencies should develop procedures and include such procedures in enforcement manuals for entering into negotiations with the subjects of investigations. And we should determine the extent to which their rules permit negotiating with subjects of investigations. Considerations to determine whether and to what extent agencies should negotiate with the subject of an investigation should include several factors. So we'll give everybody a few minutes to look at this and propose any comment, suggested edits, and if you have any comments. Or if there's anything else we should consider. That's it.
Couple things. One, I think we should look at the language easily come into compliance, because I'm not sure that seems to be ambiguous. But on E, a traditional rationale for settling a case is you get more immediate compliance. So it's good for whoever you're protecting. And I'm not quite sure that's captured by the language would be more efficient for agency time and resources. That's also true, I guess. But the important consideration is you can settle and get compliance sooner than a protracted enforcement proceeding.
A good point. So in D, is that what really D needs to be more readily or quickly come into compliance as opposed to easily come into compliance? Would that address that there too?
Yeah, more easily might be the cost of compliance to the regulated entity.
Yeah.
And I'm not sure whether that should be weighed or not.
Yeah.
Yeah. More readily or quicker or something, yeah, would capture what I just suggested. But perhaps the drafter meant something else.
Adam?
Absolutely. So I don't think that I meant anything different from what you said, Professor. I think that trying to, wrestle with the difference between a CERCLA violation and a tax discrepancy sort of weighed on my mind as we were evaluating sort of the report and how it needed to be reflected in the recommendation. And so I think something that the report really touched on very well was that agencies are going to be considering sort of the nature and the harm of whatever potential violation when they're entering into negotiation and settlement discussions, and making it, or there could be a case that the easier it is to get into compliance would affect the nature of settlement negotiation or settlement and negotiation, if that makes sense.
I see that if I were representing a regulated entity, I certainly would have that in mind. I'm not sure why that's an agency concern. Sometimes compliance is difficult, but that's what the statute requires, and that's what's necessary to protect the public or the environment.
Absolutely. I think we could debate the pros and cons of the addition as well. I think pulling out D would maintain a lot of the structural integrity of 14 sub A through what would then become E. But we can chat about it for sure.
If we keep the language more readily, can we say when the subject, whether the subject would rather than could? I do think that's a valid concern. I don't know about others.
You said and Adam. Anyone else have thoughts on D? And the changes to it? Karen?
Let me just take a quick look here. Agency should develop. I'm thinking, I'm sorry, it's a very nuanced question. Maybe would be more likely. The word readily,
I like that.
is likely it comes to like a probability, you know, and it sort of falls within sort of administrative law theory a little bit. You know, it's like, is the nudge going to cause an outcome or likely to cause an outcome? But it makes sense because there's all kinds of conduct that is extra statute, or, you know, violates a statute that no one can comply with. You know, like there's a good example of that in the, what's it, like the Food, Drug, and Cosmetics Act, like the Delaney clauses or something. Remember that? Where anything carcinogenic would therefore be a violation, but then that was premised at a time of scientific exploit where it was like 4 things that were carcinogenic, and then now any substance that we're aware of that you consume enough of can become carcinogenic, even if it's not relevant to the human diet. So just like that type of thing makes sense. More likely, or you're coming more into conformity. I think that makes sense.
Anyone else have any other thoughts on the edits?
I'm still not sure that captures what I mean.
Oh, we have a, we have a,
Oh,
we have a public.
I'm sorry.
Oh, we have a public comment that, so,
Oh,
but
please go ahead. Yeah.
I'm a
I'll-
member of
I'll
the
just wait.
public. It's okay, Sid. No, but Sid, if you want to talk, and while I'm reading it, I'm reading slow today, so Sid, please.
This is the idea that the agency is willing to settle a case for pennies on the dollar to get compliance, because the agency's job is not to make money for the federal treasury. It's to get immediate compliance, as opposed to a prolonged battle over enforcement. And would more likely come into compliance about whether the subject would come into compliance more, because that would be the point of the settlement. If others think that language captures my meaning, that's fine, but
You're right. I mean, that
whether the subject would comply with the regulation or statute violated. How about agrees to? Because there could be a contestation over, we're not really violating that regulation. And so the point of the settlement is, well, okay, if you reduce the penalty, we'll agree to come into compliance with it. So with your interpretation of what we should be doing.
All right, that's a good point. And before we allow the public member to join us, is there any objection to a member of the public commenting? If I see no objection, we can unmute our public member.
Oh,
Matthias.
okay. Sorry.
Thank you. No worries.
I was wondering if there is consideration when negotiating a settlement for like concerns of preferential treatment or appearance of impropriety, where they're like weighing the like external optics, or should they not consider that at all? That's all.
Thank you. Kara?
To the commenter, a thoughtful view, I value it. My thinking is that that is separately regulated in the context of government ethics. Is that there's just sort of a global requirement on all conduct to avoid the appearance of impropriety, which would naturally include this. So I don't think it would add value to sort of enunciate that component of federal government ethics generally, without then just sort of like lacing on all federal government ethics requirements on the entire work product. But the good news is yes, that is bad. The appearance of impropriety should be avoided at all times for everything, for government employees, including this.
Thank you, Arrow. Thank you, Matthias. Excellent. All right, I'm looking at our edits. Where did we land? Whether the subject would be more likely to agree to comply with the regulation. Any other suggested edits on this? Anyone have any objections to where we're landing?
I just wanted to know if the committee preferred
Oh.
agree to complying or likely to come into compliance with.
Thank you.
Yeah.
Eric?
What one idea to socialize this for, there's, is it an agreement to comply, or is it more likely to change behavior to come into compliance or towards compliance? Because there are some regulations for which compliance is impossible. That's like the classic anecdote that we teach in admin law. It's like, if every single regulation were to be applied against you in every statute, you'd just be violating all kinds of laws all the time. But I also don't want to get so nuanced that it seems pedantic. So are they more likely to change behavior to bring greater compliance with the regulation, or greater or total compliance? Or do we want to just take a principled view and say just it's compliance or it's not? Like Sid is right that agencies sometimes don't have discretion generally, but then they have a ton of discretion, like Heckler versus Cheney, and how they utilize prosecutorial resources. And this is sort of the front end of that prosecutorial resource allocation, which is inherently discretionary.
Yeah. Well, and part of this is, these are the factors that an agency is considering just to even think about negotiating with someone. So part of what I took here is, for D, it's really, is the other party even open to talking to you? Like if they're not even open to talking to you as the other party, why would you bother with negotiating? Like a consideration to determine whether and to what agency to negotiate with the subject to the investigation should include whether they would likely agree to complying with the originally, so for me, it's even if you're going to be entering into negotiations with them, if they're not even open, if they're not even willing to talk to you about doing this, why would you be spending the time to negotiate with them? is kind of how I looked at that factor.
I like that. I like that too, because you're sort of introducing the doctrine of like futility, or below futility is like, is there an unalterably closed mind? That's usually applied to like governments, but that could easily be applied to the target of an investigation. So like this is the committee's concept. It's whatever is best for the committee makes sense. There's like many formulations that could work here.
So that's how I was looking at it not be how everybody else was looking at it, but when I was looking at it, I was looking at it as that kind of factor for like, if I was the staff person trying to figure out whether or not to negotiate with the opposing party on it, what would be something useful to be thinking about? And that would be a factor I was looking at, but I don't know how other people were looking at it. Anyone else? I don't know if we helped you, Kaja.
No, but I think the conversation was what I was looking for, right? I do think that there's a difference in saying agreed to complying versus coming into compliance. And Helen, your point is also well taken. I mean, the only thing I could respond with is maybe like whether the subject would be more open to complying with the regulation, but I think that's probably akin to more likely to agreeing to comply. Just less words.
I think the difficulty we're having is the agency has one view about what is compliance, and the reason that the company or whoever this is being enforced against has another. And so they're saying we haven't violated anything. And the agency says, yes, you have. And so I think whether they are likely or more likely to agree to the agency's interpretation is what we're trying to get at. I'm not sure exactly what the words are, but I think we're close.
Yeah. And Sid, sometimes there's not disagreement. Sometimes
Yeah.
they'll be like, "Yep,
True.
yeah."
You caught us. Yeah.
Yeah, like the only other thing I would add, Helen, like for your agency, there's a range of it, right? So if it's like the lead paint rule, that's pretty darn strict, right? Like there's just no space for anything that's not the correct side as the EPA sees it. And then for other things, there's
a range.
There's a range, right? And I just wanted to say that.
Yeah. This is a very helpful discussion, everyone. Any other? I think it's just helping us kind of coalesce what we'd like to have in this recommendation too. Any other thoughts of what we could do with D?
I think my recommendation is like, give it to ACUS staff, let them iterate. I think it's like a 20 or 30-minute internal staff discussion because there's just so much there. And
Happy to do that.
Yeah, there's a couple of options there. Are there anyone have any other proposed edits on any of the other sub-bullets before we move on to 15? If not, we can move on to 15. All right.
Yeah, last one.
Yay. Good job, everyone. Agencies should provide and include in their enforcement manuals the relevant factors for enforcement personnel to consider when determining whether settlement is appropriate, and clearly state who the agency can propose, discuss, or enter into settlement agreements. Any thoughts, concerns, edits? It seems pretty non-controversial. All right. Did we want to go to the preamble language or wait for that until we landed on the rest of our edits for the recommendations? What do you think, Kaja?
I'm happy to go up to the preamble.
We can go
I
up to the
think we
preamble. Go ahead, sorry.
Oh, no, I was just gonna
Um,
say, I think it would be great to start tackling that, but
All right.
I don't think many of the changes that we've made in the recommendations will impact the preamble too much.
Okay.
But I'm also, again, Adam and I are happy to review all of the changes made and just make sure that if they do affect the preamble, that we include them.
That's great. Well, we've got 25 minutes, folks. Want to tackle the preamble? Excellent. Kaja, can I beg to like blow up just a tiny bit more of the print?
Of course.
Sorry.
You're good.
I'm getting older. My eyes are getting. All right. Let's start with line 1 and move down. Agencies. So let's start. How about we start with the first sentence, and then we'll go on to the second sentence. Oh, Caleb.
If it is the committee's intention to exclude routine inspections, maybe that's something to add to footnote 1.
Good catch. Sure.
If I may, one counterpoint is I would recommend that there's a number of recommendations in here that would benefit from the application to routine inspection. So for example, if the perfunctory like slip of paper that explains what you're doing there isn't provided for a routine inspection, that's something we would kind of want to be done. But I could also easily see that routine inspections, it's just a hard question. It's what is an investigation? At what point does it begin? So we talked about this in the first session, which is, let's say, like in the context of AI, all kinds of government information systems have AI. It's just sort of like running back and forth doing things. And that certainly wouldn't be an investigation. The filing of a tax return doesn't put you under an investigation, even though there's some level of analysis that's happening at the back end of the AI, back end of the IRS for the tax returns, when they're maybe deciding what to investigate or, whether to calculate differently or something. So I just wanted to, if we're going to exclude routine inspections, we just need to be really intentional about it as a body, as opposed to excluding routine inspections for, let's say, like paragraph 7 or something in the recommendations.
Mhm.
I guess I'll just add whether the committee would want to include a definition of what is meant by agency investigation and agency investigation procedures for the purpose of this recommendation.
Good thought. Anyone have any ideas? Or if after the session they draft one, feel free to share it with Asha.
My thinking is that that would probably also be good for staff to iterate on. It's just like a really, these are truly novel, nuanced questions.
Yeah, we're happy to do that. I think we can also look at previous, whether or not we defined it in any previous recommendation as well.
Because like the report talks about a lot of these things, but it's just like such a delicate question that there is no easy answer. But we're charting our own course now for the first time.
And I also saw Jay's hand come up, so he might have some thoughts on this.
Unfortunately, it's not a solution, just a little bit more of a problem, which I was planning to raise a little bit later. But as being a representative of an institution that engages in ordinary course examination and supervision of financial institutions where we're constantly on site, having these provisions apply to that entire relationship seems challenging. So I have some language that was thinking might be appropriate in around line 29 to address that and just make it clear that it's not the expectation that in all circumstances our in-house examiners are conducting themselves in the way described here. But as you're talking about excluding routine inspections and the like, I wonder if that might be an appropriate place to exclude or at least limit the applicability to financial regulatory agencies that are engaging in ongoing supervision of financial institutions.
Did you say you had some draft language you could share with Kaja?
Yeah, so happy to read it out and then I can send it separately. So we were thinking around line 29, where you're talking about the limits of how this might apply. Something along the lines of, indeed, investigative procedures may present challenges for financial regulatory agencies in the performance of ongoing supervision because adopting excessively rigid rules could impede the flow of information and make it more difficult for examiners to identify problems that impact the safety and soundness of an institution.
You could just pop that in the chat. That would be great.
I will see if I can figure out how to do that.
Okay, thank you.
You just gave us a whole new thing to think about. And Shin, I saw your hand go up, so.
Well, this is a very much unbaked thought, but inspector generals routinely just have separate departments devoted to investigations as opposed to audits and inspections. And so, if you're looking at this, it may be useful to see how they distinguish the two, because I think the investigations they do are much more similar to what we're talking about here. And I think their audits and inspections are, similar to what we were just talking about with respect to financial regulators. So.
Thank you. That's helpful.
Yeah, these are good observations. So responding to Chin, different IG offices have like a wide range of different domains. So the one example I'd want to give is the IG's office for the Health and Human Services is especially powerful related to, let's say, the subject of this work product, because they're typically the prime investigative entity for what eventually will develop into False Claims Act enforcement actions by the U.S. Department of Justice Civil Division Commercial Litigation Branch, for which all of the sudden, like everything in here starts to sort of light up like a Christmas tree in terms of utility. And then there's other IG functions, even within like that same IG's office where like they're like super routine, not non-significant. Oftentimes these IG offices focus like internal within the government. But when it comes to grants, for example, and grant allocations and federal financial assistance, it is where like I would strongly advise that these procedures are quite useful for those IG practices as well. In response to Jay's question, so the reserve board is distinct. My counterpoint to that is I would feel awkward to exclude all financial regulatory entities from the domain of like significant parts of this recommendation, because the board itself is sort of so unique in terms of just how integrated and how close and almost like how collegial the relationship is between their regulated entities, like their depository institutions, and the board itself, relative to other financial regulators where it's a lot more arm's length, and for which like, these requirements are especially useful. So I just wanted to put that out in the air for consideration.
Thank you. Chin, is your hand up again?
No. thanks.
Okay, no worries. Jay?
Sorry, maybe just to respond to that. So completely agree. We're very unique. I guess with respect to this, though, I think that the other bank regulatory agencies are quite similar in the way that their examiners engage with the financial institutions they supervise. So I'm not suggesting an exclusion for all financial institution regulators, just with respect to, you know, those that have authority to conduct ongoing supervision, because that's, you know, that's where the relationship is particularly unique, and that covers, you know, us, the OCC, the FDIC, and the NCUA.
I think that makes sense. And I might even go further to say like, and the authority and the practice of doing so. Because I could see a circumstance where the authority exists, but the practice is more arm's length, you know, for which like, you know, these recommendations make more sense. But for what your institution is, it's just like, unless you have that like open and free flow of information all the time, like essentially like a trust partnership almost type relationship, you know, then you can have a breakdown. That does make sense.
Great. Thank you, Jay, for lifting that up for us. We'll put that marker down to follow up on. And then we'll go back up.
Yeah, I was gonna say I'll scroll back up.
Well, we made it to the first sentence. We got 13 more minutes. We're doing well, everyone. To the second, investigation enforcement processes. Decision. I guess on the second sentence, this is the first time we introduced the concept of compulsory processes. Is this where we really define compulsory processes for the first time?
No, we have a paragraph further down that
Okay,
defines it more.
all right. Right, anyone else? Oh, Jay.
Sorry, that's legacy.
Or that's all I can see. Okay, thanks. On to the next sentence. Administrative conferences previously recommended best practices. Anyone has any comments? Nothing on that. Nothing on that. Within the next sentence starts with to build on those recommendations. This recommendation identifies best practices to improve transparency, fairness, and efficiency in agency investigations while preserving agencies' ability to fulfill their regulatory missions effectively. Seeing no hands, we can go to the next paragraph. Agencies are governed by statutes and regulations that delegate enforcement authority. We'll start with that first two sentences. They really describe any edits or concerns or comments on this paragraph? Not seeing any hands. Maybe go to the next paragraph. Agency investigative procedures vary depending upon other things, statutes and regulations. Let's see. Good.
Doesn't necessarily directly relate to this paragraph, but does go back to the discussion or discussions we've been having. Do we want to say somewhere we recognize the vast variety of different kinds of investigations, agency functions, so on and so forth? And what may be a good practice generally may not be an appropriate practice in a given instance or something like that?
All right. Oh, there.
Sorry about that. I think the premise is utterly true. Yes, I've said it like, said it how many times. My question would then be for ACUS purposes is providing savings clauses like that. Just sort of like a ripcord that any agency can then just pull and be like, well, that wouldn't work here, and then they just walk away. So what's the norm for that? And because I would recommend against putting, I would definitely acknowledge there's a wide array of things, which implicitly then implicitly lays out, well, if everything is very, very broad, these limiting principles capture a lot, but they might not capture everything. And that, but if having that second clause in, I'm just cautious because that can just allow an agency that's not terribly interested in advancing best practices just to be like, that's too much. Stop.
Well, they're probably not going to do it anyway, since it's a recommendation. I mean,
yeah,
we've
it's the
often
Sisyphean
used
nature of the conference, right? So, yeah.
Correct. We've often used language as appropriate, as relevant as, and the individual
Yeah,
recommendation.
if that's the norm, then
so asking agency, there certainly could be an expectation these are good practices, but agencies should evaluate on a case-by-case basis their use or something, without saying which way they should go. But I don't know whether that belongs in a preamble or it's just implicit in what we're doing, but we're having a lot of trouble because there are lots of instances we've heard where a particular good practice may not be a good practice.
I just wanted to bring up Jay's proposed language. I think he dropped off. But I do wonder if what he had said kind of also addresses that. Fortunately, I don't have it yet. So
Yeah. Yeah, when we get that, we can look at it and kind of try to incorporate that into that. Maybe it's something to noodle with and incorporate.
yeah, I was going to say I'm happy to add a comment that staff can address this. As Sid mentioned, this is certainly something that we've done before in previous preambles. It's not uncommon. But I do take Arm's note about kind of making sure that there's room to not give agencies, I think, an excuse.
Kind of a standard best practices as much as possible for agencies to utilize, noting that there could be some deviations based off of unique authorities or structures for some agencies. Something like that. I realize we are down to our last 5 minutes. Do we have any housekeeping we need to do, Kaja, before we can wrap people up?
No, I mean, no, we have a third meeting scheduled for Wednesday, April 9th, 1 p.m. to 3 p.m. So again, we'll send out the revised recommendation, incorporating today's edits that were approved by the committee. Again, if you have any additional comments, I strongly urge you to email me separately and just give me proposed language as much as possible is very helpful. Depending on how far we get through that meeting, we may go to a fourth one, but we're going to try not to.
Well, I just want to thank you, everyone. This has been you guys are doing great. This committee is fantastic. The conversations have just been really helpful. And thank you for all your insight as we go through. This one's thorny. It's important and it's not an easy one to tackle. So thank you as we work through these recommendations and the language on it. So look forward to talking with all of you at the next committee meeting. Thank you, everybody.